Davis.
Thank you, Mr Speaker. Mr Speaker, the Māori Purposes Bill is an omnibus bill that changes how the Pukepuke Tangiora estate is administered and amends three other acts, those being the Māori Fisheries Act 2004, the Māori Trust Boards Act 1955 and Te Ture Whenua Māori Act 1993. The changes to the Pukepuke Tangiora estate have come about as the result of a petition of Hariata Baker, one of two sisters who are the surviving beneficiaries stipulated by the will of Pukepuke Tangiora, their grandmother. The original will of Pukepuke Tangiora, which came into effect in 1936 upon her death, provided for the estate to be managed for the benefit of her son and his wife and their 9 children. Hariata Baker and her sister Kereni are the last 2 of those 9 children. Parliament has changed the effect of Pukepuke Tangiora's will by legislation through the Māori Purposes Act on 6 separate occasions between 1943 and 1973. As a result of these acts, current legislation relating to some aspects of the will of Pukepuke Tangiora differs significantly from that which pertained when the will was written. Hariata Baker and her sister Kereni are in their late 70s, and upon their deaths the land will be free to be sold. They sought the reinstatement of the provision that land be held for another 20 years after the death of the last beneficiary, as envisaged by Pukepuke Tangiora, but removed by the Māori Purposes Act of 1943. However, the bill as written proposes to extend that period instead to just 5 years after the death of the last beneficiary, to provide enough time for beneficiaries of the estate to make decisions on a future governance entity to hold and manage the estate assets. Hariata fears that upon her death, pressure will continue to mount for the land to be sold to clear the way for the coast to be developed, ultimately destroying the unique and valuable character of the area. That area being Ocean Beach, which was described in an editorial from Hawke's Bay today as one of the gems of the Hawke's Bay. The Select Committee believe that the Council and the trustees have not acted in good faith towards the beneficiaries, which has led to a prolonged and unnecessary court case in order to protect their land. As the Hawke's Bay Today editorial continued on to say, there are a number of vested interests pulling in different directions at Ocean Beach. Pukepuke Tangiora Estate, Waipuka Incorporation, which cannot agree with each other or among their own beneficiaries. Tennyson OB, which stand to make a lot of cash if the dice rolls in their favour. Haupori Station Limited, a several generations old farming business which wants to continue farming but has gifted land to the council and sold land to potential developers. Then there's the anti-development group Future Ocean Beach and as well the council. Reverting to the original terms of the will would considerably ease the tension over the land, and although it would not bind the land in perpetuity, it might safeguard the land until more enlightened attitudes to coastal development prevail. The bill also proposes amendments of the Pukepuke Tangiora estate so that the Māori Land Court and not the Crown have jurisdiction to hear all matters relating to the administration of the estate. Mr Speaker, this bill also makes amendments to the Māori Fisheries Act of 2004. An unintended consequence of the Māori Fisheries Act was that it prevented the transfer of fisheries settlement assets of a mandated iwi organisation to another separate entity of the same iwi. Any attempt to transfer those assets would trigger a provision that would require the sale of those assets to the highest bidder. This, in effect, could strip fisheries assets away from their iwi. This bill proposes that the iwi are able to transfer certain fisheries settlement assets to other separate entities within governance arrangements of the same iwi, which in effect rightfully allows iwi to assert tino rangatiratanga over their own assets. This bill also amends the Māori Trust Boards Act of 1955. Mr Speaker, at present the Māori Trust Boards Act 1955 makes Māori Trust Boards accountable to the Minister of Māori Affairs. Similar governance entities are not subject to the same conditions of accountability. They are instead accountable to their beneficiaries. This bill proposes the same practices that apply to those other entities also apply to Māori Trust Boards, and as a result of this bill, Māori Trust Boards will too become accountable to their beneficiaries. This means, Mr Speaker, that trust boards will be required to hold annual meetings where they will report to their beneficiaries on their activities over the course of the year and present an annual report including a financial statement and a budget. Mr Speaker, this means that the beneficiaries of trust boards can attend those annual meetings and hold the trust board to account. And it is no longer the Minister of Māori Affairs who the trust board reports to. Instead, those annual reports, financial statements and budget will just be sent to the Minister of Māori Affairs for his information only. Mr Speaker, part of the bill relates to the Māori Land Court and extends its powers to reflect those powers of the District Court to award interest on debt or damages. The amendments will ensure that an order of the Māori Land Court filed in the District Court may be enforced as if it has equal status as an order of the District Court, which includes being removed into the High Court for enforcement. Mr Speaker, the Māori Land Court has been in existence in one form or another since the passing of the Native Lands Act of 1862 and the Māori Appellate Court since the 1890s. The Māori Land Court has jurisdiction to hear matters relating to Māori land, including successions, title improvements, Māori land sales, and the administration of Māori land trusts and incorporations. It also has jurisdiction to hear cases under the Māori Fisheries Act 2004, the Māori Commercial Aquaculture Claims Settlement Act 2004 and a number of other statutes. As at September 2009, there was approximately 1.47 million hectares of Māori land, which comprises less than 5% of land in New Zealand. While the total area of Māori land is small, the court and its administration recognises the special bond that Māori people have with this land. Thus, the maintenance and preservation of the court's record, containing as it does invaluable customary information, including whakapapa or genealogy, remains a fundamental feature of the work of the court. Mr Speaker, Labour supports this bill to Select Committee. However, with Māori unemployment double that of the general population, this bill does miss an opportunity to make real progress for Māori. The issues burdening our people are unemployment, the cost of living, inadequate housing and real progress in lifting wages. The cost of fruit and veggies continues to rise. We heard today how it's getting more expensive to go to the doctor, and with the cuts to early childhood education, parents are being expected to dip deeper into their pockets to get their young ones an education in their most formative years. This at a time when the Statistics New Zealand Income Survey show that the median Māori income from all sources has gone backwards over the past 2 years by $41 a week, which probably explains why we have heard over the weekend that families are being forced to buy cheaper cuts of meat normally used for dog food. Mr Speaker, when people get to that stage, we know that more drastic measures than what is being amended in this bill is necessary to improve outcomes for Māori. Mr Speaker, the Labour Party supports this bill to Select Committee, but it is a missed opportunity to make a real difference for Māori and to reduce disparity for our people.
Tēnā koe, Mr Speaker. Mr Speaker.